Hello, welcome. Welcome to this season's fifth episode of Schwegman, Lundberg, and Woosner's Chemistry and Biology Seminar Series. I am Nicholas Lanzatella, your moderator for the series. During this series, attorneys from the SLW law firm having a background in chemistry or biology will present on various topics that are at the intersection of chemical or biological sciences and patent law. We will aim to give these presentations on the second Tuesday of each month. If you attend three or more of these presentations live and you have a mailing address in the United States, we will send you a free gift. Slides for today's presentation will be available in the chat and a link will be emailed to you also. As a reminder, nothing in today's presentation should be regarded as legal advice. If you are seeking legal advice, please consult your legal counsel. Our speaker today is Trevor Lind. Trevor is a principal at the firm and is a registered patent attorney with expertise in chemical arts, electrical arts, and life sciences, such as cloud computing, computer hardware, software, polymers, solutions, semiconductor processing, small molecules, synthetic biology, sequencing technologies, medical imaging, and medical devices. Trevor also has unique experience in the complex intersection of the life sciences and chemical arts. In particular, he has experience working with DNA computing technologies, machine learning to predict patient outcomes, machine learning to design large molecules and optimize large molecule production, and algorithms to analyze and evaluate clinical trials data. Trevor received his Bachelor's of Science in Chemical Engineering and his law degree from the University of Texas at Austin. Today's presentation is entitled Legal Frameworks for AI in Life Sciences, Patent Law's Adaptation to Technological Innovation. I'm very excited to hear Tyler's presentation today. If you have questions, please put these in the Q&A of Zoom. So if you go to the bottom of your Zoom window, you should see a little box marked Q&A. Insert your questions there, and Trevor will answer these during or after the presentation. Go ahead and take it away, Trevor.
Thanks a lot, Nicholas. Thanks everyone for being here. I'm so glad that you're joining us. My goal really today is to try to help provide information that's helpful to you and that you can use in your practice or if you're developing technologies in the sort of the technology development pipeline. These are some of these issues are issues I deal with on a day-to-day basis. And some of them are a little more theoretical. So I think that will be hopefully interesting to you and just to kind of see where the law and where the technology end up taking us to. Like Nicholas said, I've been practicing law for about 20 years, over 20 years. And for the past 9 years, I've sort of had this mixed practice where I've practiced in the electrical arts and then chemical life sciences. And then now, over the past 9 years, it's really been some of my practice is this intersection of the life sciences and software and AI. So it's been fascinating to see how things have changed over time, and hopefully I'll be able to provide some good information today. So can you go to the next slide, Michelle? And then probably the next one. Okay, great. So one thing that I've noticed is that over time, technology it changes at a rapid pace. So saw the internet and how things went really quickly with that. Lots of changes taking place, and now with AI, we see the same thing. And a lot of times, the law has a hard time keeping up, and sometimes the law can become outdated. And so what happens is regulatory agencies they step up and they try to be able to fill in the gaps where the law isn't really speaking to at any given moment. And so when I say the law, I mean, there's two different forms in that there's the statutory law, which really can be lagging, and then there's the judicial law, which tends to be able to move a little bit more, but sometimes it's also lags as well. And so what this can do is it can create a messy middle. And I remember I started thinking about this probably about more often, probably about 10, 12 years ago, maybe even a little bit longer. I worked with a really great FDA attorney. Her name is Carol Pratt, and she would do these presentations, and I was always amazed to be able to hear about how at the FDA for so long they were looking at digital health innovations and devices more using 1988 or early 90s regulations and laws to be able to sort of evaluate these digital health technologies. And I remember sitting in some of those presentations thinking, wow, why did they let things get to this point? Why didn't they really, try to be able to keep up with the way that technology was changing? And that was at the time, it was very early on with Alice, and they had just sort of promulgated some of the FDA's regulations on digital health. And so I didn't really see that so much in patent law at the time, but now I think I find myself in that pretty often. And another thing that sort of helped with coming up with the idea for the webinar is a few years ago talking to a company who said that they had simulations that they could do that were more predictive than animal studies for certain therapeutic treatments. I thought that was fascinating, and it just helped. And then I just sort of started thinking, well, what is this going to mean for the future? And so today's presentation is based on and is kind of that's sort of the genesis of it in my mind. And so I just thought I'd share that a little bit with you. Next slide, please, Michelle. So we'll look at three areas where we have, a certain regulatory framework. It's either adapting and maybe in some cases not to technical advances. One of those areas is on the impact of AI usage and inventorship, which is pretty new. And I don't think we're in a messy middle here, but we could very easily go down that direction. Subject matter eligibility. I feel like I'm in this fight all the time. Hopefully, I can share some good insights. I've seen some positives coming through lately, which is nice, but I feel like there's just still so much uncertainty. And then the last one will be the submission of in silico data for enablement purposes. So I had first thought about that a few years ago when this company had mentioned about their simulations working better than being more predictive than animal studies. But then since Amgen, I've started to see more articles talking about this idea. And some folks are really bullish on it and some aren't. And I think that there's a lot of risks involved with trying to do something like that, but maybe down the road we'll kind of see how everything ends up going. And Europe at least is talking about this in some of their decisions, but I haven't really seen a lot from the US. So those are our three topics for today. So Michelle, can you go to the next couple slides? There you go. Great. So with AI and inventorship, I thought we could start with Thaler versus Vidal, which is a case where someone named Stephen Thaler, he filed two patent applications listing DABUS as the inventor. And DABUS is one of his, it's an AI that he developed, and it stands for the device for the autonomous bootstrapping. And he filed two patent applications, and he listed a creative software as the inventor, and that's DABUS. And interesting, I thought that was really interesting how he signed the declaration on DABUS's behalf because DABUS can't sign it. And then he also filed the assignment to the patent application to him from DABUS. And so he filed his patent applications, and the USPTO sent a notice of missing parts because there was no human inventor that was listed. So Thaler didn't agree, and so he appealed to the district court and then to the federal circuit, and ultimately tried to go to the Supreme Court, but the Supreme Court ended up denying cert, and the federal circuit held that an individual in the patent statute means a natural person or a human being. So I think that this is actually very similar where to cases, you even see this maybe in animal cases. I don't know how familiar you are with the animal selfie case, where it's sort of who has standing and who doesn't. But individual in the patent statutes is supposed to mean a natural person or a human being. And the Supreme Court precedent talks about how when the word individual is used in the statutes, it means a human being unless it's clear that Congress intended a different meaning. So Congress would have put it in the statute if they wanted individual to mean something else other than a human. And so in that case, because of that, the Federal Circuit held that Dabis could not be an inventor. And we've seen, throughout the world, there have been lots of, different guidance and decisions coming out around this that have made similar decisions. One example where they found that you could be AI is South Africa, but they have a pass-through system. They just basically register the patent applications. There wasn't really like any kind of formal examination or determination of inventorship and that kind of thing. So, but all major jurisdictions throughout the world have said that you need to have a human be one of the inventors. Next slide, Michelle. So, so the USPTO saw, so at first, when I heard this decision, I thought, oh, okay, great. So we don't have to worry about AI being inventors. So, what do we have to worry about? So in 2024, the USPTO put out guidance on AI and inventorship, and it said that, AI-assisted inventions are patent eligible as long as a natural person made a significant contribution. So that was the standard that they had initially set out. Um, and they provided examples of what may and may not be considered a significant contribution. And I felt like the example was really interesting where they used it's a mechanical related situation where you're creating a transaxle design for a car. And they sort of went through different scenarios and said, yes, there's a significant human contribution here, or there's not a significant human contribution. And so they based a lot of the guidance on the Panu case. And so in that case, it generally discussed how to determine if a natural person was a joint inventor. So yes, somebody is an inventor, or no, they're not an inventor. So did that person contribute enough to sort of rise to the level of being an inventor? And so that's what the standard was in 2024. Next slide, please. So, but then in 2025, they rescinded their guidance. So they said, nope, we should not focus on significant contribution. What we're going to do is we're going to focus on conception of the invention. And so what they did is they took a lot of statements from a case called the Burroughs Wellcome Company versus Bar Labs. And that company is more focused on, so it's interesting. It's a 1984 case. So this was a while ago, and it was more related to first to invent, and it was about treatments for HIV and who invented first. And so that's what the inquiry was: is when did conception of the idea happen? And so in that case, who ended up, who was the first to invent? And so that sort of framework is gone now with the AIA. We're a first to file. But that's the language that the USPTO seemed to be able to take and focus on in their new guidance. And one thing that's interesting and that always makes patent practice tricky is both the 2024 guidance and the 2025 guidance. And the 2025 guidance is November of last year, so it's less than 6 months old. And I think a lot of times, or at least in both these situations, it was the guidance came out not too long after different executive orders. And so sometimes when there's leadership changes at the PTO, we see these sorts of things happen. And so now in 2025, we have this new guidance that rescinds the 2024 guidance. Next slide, please. So here are some quotes from the 2025 guidance. And I just thought it's sort of helpful to kind of run through these, but there's a lot practically, what does this mean? So it talks about conception is the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is hereafter to be applied in practice. And then conception is complete when the inventor has a specific settled idea and a particular solution to the problem at hand, not just a general goal or research plan. And the main question that they brought up, they talked about this in the Wellcome case, is that whether the natural person possesses knowledge of all the limitation of the claimed invention such that it is so clearly defined in the inventor's mind that only ordinary skill would be necessary to reduce the invention to practice without extensive research or experimentation. And so I thought that this, it's really interesting to sort of see how they've gone from the significant contribution standard to the conception standard, but like I had mentioned, there's not a lot of practicals, and it's a very fact-dependent inquiry into this sort of thing. Um, and so one of the other things that they had talked about in the guidance was is a tool that can be used by inventors, and so they analogize to laboratory equipment, research databases, other types of software. To me, that seems a little bit like an imperfect analogy because AI does more, but you're still getting, input from the machine learning to be able to sort of help you in your development process. Um, but that's how the USPTO ends up seeing it. And they talk about how, services and ideas can aid others without becoming co-inventors. And so that's sort of the standard that they're applying now. And then they wanted to make clear that it applies to design and plant patent applications. So not just utility, but design and plant. And a lot of other countries have provided guidance on this issue, some similarities, some differences. But generally, everyone is trying to be able to sort of figure out how you attribute and what you attribute on the inventive side to human contributors. Next slide, please. So I felt like, generally the USPTO presumes that the inventors are those that you've listed, and they don't make inquiries into inventorship, which tends to happen a lot more often in litigation. But I felt like it was fascinating as I did more research on this that it's possible for them to be able to make these sorts of inquiries. So there's examiners under 37 CFR 1.105 can make requests for information. And I have not ever received one of these before, but I was so surprised at how expansive and what some of the examples were that the MPEP lists could be part of one of these requests for information. So some examples are a copy of existence of particularly relevant commercial databases that are known to the inventors, a copy of non-patent literature, published application, or patent that was used to draft the application, a copy of any non-patent literature, published application, or patent that was used in the invention process, such as by designing around or providing a solution to accomplish an invention result. Another is technical information known to applicant concerning the related art, the disclosure, the claim's subject matter, other factual information pertinent to patentability, or considering the accuracy of the examiner's stated interpretation of such items. And so I was very curious about this, so I started looking into it and what situations have come up where people have received this, and I found a couple where the request for identification may have come out if there's a co-pending application and they would request information on the co-pending applications and any claims that might have a double patenting issue that might raise double patenting issues. And then maybe a request to narrow down. So if an IDS is filed with a lot of references, they might request to be able to narrow down that to to fewer references. I saw there's a Reddit thread about this, and there's not a lot on there, but it's interesting to be able to see that it seems to be disfavored at the USPTO. Some examiners have tried to use it for various things, and there's been some pushback. So in any case, I just felt like this was very interesting that, and I don't know that the inventors have time to be able to make these kind of inquiries, but I think, and we'll talk about this a little bit later, depending on what's in this patent application, if someone sort of feels like, wow, is this maybe AI, is the AI sort of contributing to what's in these claims? Maybe someone would make a request, I don't know. But then there's also, we all have our duty of candor. So that we have to be able to follow and we have to, disclose information that's material to patentability. And I think that, when declarations and oaths are signed, it has to be with the belief that they are the original inventors. And so there's no new requirements to disclose AI, but I think it's important for practitioners to be able to just make sure that we're sort of looking at this kind of issue so that to be able to help our clients so that they don't the down the road inventorship inquiry doesn't invalidate the patent because under 101, if there's no human conception, you might have a rejection or invalidity. But also just to be able to make sure that we're operating with our own duty to our clients into the PTO. Next slide, please. Okay, so the impacts of AI usage in technology development. So we want to be able to basically try to show that there's no AI inventors whenever we are drafting a patent application. And so, but what I think is going to happen is there's likely to be increased scrutiny of who conceived of what. And we need to be able to be prepared for that. And I'll talk a little bit about that in just a bit. It could be that enforcement actions begin to see inventorship challenges regarding AI and inventorship. Especially there's no technical inquiry really involved. It's just who contributed what. So you don't have to get into 102, 103 issues, not even 101 issues. It'll be very interesting to see how much this is used, if it's being used. I've seen a lot of articles about this and folks talking about it. So we just have to wait and see. I think we're at this point where there's the Thaler versus Vidal case. There's not really a lot of testing in this yet. So, and I'm not aware of any cases like this. If you are, please email me. I'd love to be able to read them and hear about them. But I think that this is something going forward to be able to be aware of. Next slide, please. So, what can we do to be able to try to help guard against these inventorship challenges? So I think documentation of AI usage and human contributions is definitely part of it. And I feel like, lab notebooks and those sorts of things are really commonplace with life sciences companies. And there's a lot of electronic ways of documenting and keeping track of the technology development process. And so I think but it seems almost a little counterintuitive. Do you use it for AI because it's software related and it's not running experiments in a lab? But I think that uh, these sorts of tools might be able to be really helpful to be able to sort of track what the human contribution is and what's happening. But it may require training, retraining. It may require obtaining these tools and just making sure that they're integrated into the technology development process. So also building AI usage and inventorship inquiry into the invention disclosure process, which could include having, invention disclosure forums updated, asking, was AI used, and just sort of flagging that to be able to make sure that when the invention disclosure meeting takes place, that this is something that's talked about. And it can go along so often in disclosure meetings, we'll talk about, who invented what and just be able to make sure that we have the inventorship right. So it's sort of an extra layer to that discussion to be able to talk about, well, what did you use the AI for? How is it used? And just ask these questions. And so AI can help you to develop AI by writing code and those sorts of things. But AI can be used to be able to provide solutions to problems, any problem. So it could be so just like the USPTO example where it was designing a transaxle. You could, what if you want to design lab equipment in a certain way and you use AI to try to help you, or you have a bioprocessing line and you need to change some parameters or configurations, and how is it going to work the best? And was the solution coming from AI or was it not? And so this can be found in so many different areas and in so many different ways. And so I think building it into the invention disclosure process is important. And then, during all of that, identifying the human contributions versus the AI contributions and making sure that the claims are focused on the human contributions. And so that might be tricky at times, depending on how the AI was used. I think if AI provides, and so some ideas around this are, if AI provides a number of solutions to a problem or suggestions related to an issue, if the human chooses one of those, why did they choose that one? And then how was it modified later on? And what was the human contribution to coming up in the end to the conception of the invention? So I think that So I think that's going to be important through the whole invention disclosure process. And then I put this in here to talk about using caution when describing AI usage and experimental examples in papers, because sometimes papers can be really detailed, research papers can be really detailed about, oh, this is how we came up with our solution. And if you put into the paper, how AI was used, and then it's just important to be able to look at that and make sure that the claims aren't focused on those aspects within the research paper, but they're focused on something else. And so I think but it's also important to be careful what's put in there, and even in experimental examples, um, just having just having an eye towards the idea of AI usage and how much you want to talk about that publicly, how much you want to talk about it in-house, and then how that all impacts the claiming strategy. So I feel like this is an area where uh, not messy middle yet. There's lots of open questions, lots of uncertainty. It could become um, really difficult down the road, and I think it's just trying to be able to think about how can we do our best job in making sure that if there's any inventorship challenges down the road to the patent applications that we're drafting, how can we sort of minimize the risk and that sort of thing. So that's all I've got for the AI and inventorship. And now we can move into subject matter eligibility, which is where I feel like we've been in the messy middle for a long time, and just trying to be able to work our way through it as best as possible. So next slide, please. Okay. So I'll run a little bit through the just through the framework that I think a lot of us are probably familiar with on subject matter eligibility. I'll add in a couple of things about that framework, and then as we move along, I'd like to talk about practicals, talk about some things that I'm seeing from examiners now that I haven't necessarily seen before. I've very encouraged over the past couple of months to have received calls from examiners asking me about potential amendments to bring claims into condition for allowance, which I hadn't received. And one thing I'll sort of say when I talk a lot about this, I'm talking mostly about TC 1600, but I see cases where you have AI usage in the life sciences in 3600. I've seen them in others as well. So sometimes if it's really machine learning heavy, you might see it in 2100 or 2800. It just sort of depends. And so in some cases, at least what I found, when the application is outside of 1600, uh, I've seen a lot less pushback on subject matter eligibility than I have in 1600. So I'll share about many different scenarios, but the main one that I'm focused on, and the main one where I've seen a lot more movement in this, is in 1600. And I did some additional research that I can share a little bit more about later on. But anyway, so subject matter eligibility, whoever invents or discovers anything new or useful process, machine, manufacture. So I think we're all familiar with that. And so it's very open, very broad. But then the courts have come along and said, nope, there should be some exceptions to this, and we should be able to sort of make sure that this is limited. So next slide, please. So based on Supreme Court and Federal Circuit precedent, we're familiar with mathematical concepts, our judicial exception, methods of organizing human activity, and mental process. The place where the two of these that I see the most, where we're dealing with AI and software that's related to the life sciences, is in the mathematical concepts and in the mental process. Sometimes I'm surprised at how much more, how still see mathematical concepts, but not quite as much. And there's still a lot of mental process. And I think that there might be some ways that we can address that, especially given some of the new guidance from the PTO. But next slide, please. Okay, and so I didn't do a flow chart. I just did simple in words. If there's a judicial exception, are the claims directed to an abstract idea, which is Alice step 1, but the MPEP USPTO step 2A prong 1. If there is an abstract idea, do the claims as a whole integrate the judicial exception into a practical application? And so they often will evaluate additional elements in that. And then does the claim as a whole amount to significantly more than the judicial exception? And then the last step 2B is do additional elements add an inventive concept. So it's really one of my colleagues, Kurt Iverson, did a CLE last week just on subject matter eligibility, and he sort of made the point that he broke down just software cases, and he said, well, a lot of the cases, most of them that have found that there was patent eligibility were sort of more step 2A prong 1 and not so much step 2A prong 2 or step 2B, even though that's where we find ourselves at the USPTO a lot of times. I thought, oh, that's very interesting, and um, once the new USPTO guidance came out last year, I started to sort of look at this a little bit. I made the same arguments, but I've structured them differently, and I actually had some success. So we'll talk about that a little bit as we go on. Next slide, please. So there's been lots of USPTO guidance over the years. So there's 49 USPTO examples on subject matter eligibility. There's 36 came out from 2014 to 2016. There were 2 times they released examples in 2019 that got us 37 through 46. And then 2024, we got 47 through 49. They span lots of different technology, applications of technology. Some are related to life sciences, and we'll look at those in just a second. There are recent memos that have come out. So in August 4th of last year, there are reminders on evaluating subject matter eligibility of claims, and talk a little bit about that. Late last year, just a reminder that 132 declarations can be used for subject matter eligibility, which I was happy to see this. I thought that was very interesting and fascinating. And then the next day, there was a notice of the change to the MPEP based on the Desjardins decision, where we got some really, I think the director's trying to be able to help. So I think it seems like there might be a policy worry that the U.S. might fall behind if we don't allow patenting of AI related inventions. And so I think that he's trying to be able to sort of help open things up a little bit and maybe get some less pushback on the 101 side. And so that's sort of why we got the Desjardins case and decision, the appeal decision, but then also making some changes to the MPEP to actually make those more explicit. Next slide, please. So here's some that can be helpful for subject matter eligibility. And so the caveat, and I don't know if any of you have had a similar situation. I've definitely argued lots of different examples, but I have had examiners say in interviews, well, that's just guidance and I don't have to follow it, which is a little bit deflating because we have these examples. We're trying to be able to, analogize to them and say, oh, this is very similar. And then they say, well, we're not going to follow it. And so that makes it really hard and very challenging. And then I see a lot of times where the examiners will sometimes try to, make an exact correlation. Well, so like with example 39, you're not training your neural network for facial detection, so am I. So your claims aren't able to be evaluated under example 39. Even though the examples do say that these are just examples and they should be a tool and all these sorts of things. So I guess that can cut both ways. But example 39 is nice because it talks about training a neural network, and there's lots of machine learning training that goes on with AI related cases. And so that can be very helpful, as long as that's in the specification and it's in the claims and you can be able to make that argument. It definitely can be helpful in overcoming 101 rejections, and showing that there's no mental, it's not a mental process. And I'm seeing, thankfully, a little bit more, especially in 1600, that if you're doing training around machine learning, there's more openness to say that the practical application is not being recited in the claims, but it just involves mathematical concepts. So that's something that's nice. And I think that's probably why I'm seeing fewer mathematical concepts, is because of this recognition that that the AI is using them, but not necessarily reciting them. Um, Let's see. Oh, so 43 and 49. Okay, so these are really interesting. So determining patient conditions and providing treatment, and sometimes the specificity of the treatment is important, and that's what they've gone through in examples 43 and 49. When I was preparing for the webinar, I just started going through, there's lots of tools out there where you can sort of look at recent dispositions in examiner cases and just sort of seeing, well, um, what did in the cases that have been allowed recently, what was the reasoning behind that? And I saw several where you have a sort of a treatment step at the end, and I've always felt like, based on examples 43 and 49, that there should be a little bit more to it than just saying that there's a treatment, and there has to be some specificity. Um, and there was that to a certain extent in some of the cases that I saw, but it was more general than I had expected. So I think it can be helpful to include that sort of disclosure within the specification, and maybe that's something that can be helpful down the road in prosecution. So I've at least seen, I have not done a case like that specifically, but I have seen that in the research that I did in getting prepared, and I was surprised how the treatments weren't as specific as I thought they needed to be. I was thinking more Vanda related and being more specific on dosing and that sort of thing. And I think that's probably the safest way to go, is to make sure that Vanda's um, satisfied, those requirements are satisfied, and so that there is some specificity, but it's just something to have in the toolbox that might be helpful. And that's sort of that's what ultimately I'm trying to get at with part of the subject matter eligibility, is providing a toolbox of drafting and prosecution um, strategies that I've seen be helpful, and be able to just share those with you. Um, so examples 45 and maybe 46. 46 is very cattle related, and it's interesting, but the gist is sort of similar in that something physical is being controlled through you're sending signals to a device, and some kind of control is happening. And I have actually seen this work great in bioprocess situations where there is an algorithm that's analyzing the data that's coming in from sensors throughout the line, and then they're control that so that data comes in, you have to modify the operation of a particular piece of equipment. The signals are sent to that piece of equipment, and then the piece of equipment operates differently. And so the 45 is a controller for injection molding, and 46 is sort of operating a gate for letting cattle in and out of a pen. But it's sort of the similar idea that if you're sort of using AI, or just, maybe not AI, just some sort of computational model in order to be able to determine different conditions for a process line, you can send those control signals to that, and that being able to sort of change the operation of that piece of equipment ends up being a practical application in the examiner's mind. Oftentimes, I have not seen one of these in 1600, maybe in 17, but I have seen that be something that's successful. And then examples 47 and 48 around anomaly detection and speech analysis, directed to finding subject matter eligibility through practical applications and improvements, with some caution on mathematical concepts. So, one of the examples talks about using gradient descent in order to be able to minimize a loss function, and they found that as being a mathematical concept. I have seen this where I had a number of different models that could have been used to um, perform certain operations, and some were very machine learning heavy, some were more statistical, and that's one of the cases the examiner called and said, if you put the machine learning ones in, then we can allow the claims, but you have to keep the statistical sounding ones. I wouldn't even say that they were statistical, they just sounded that way, to be able to keep it out, and that was a little bit frustrating. So to be able to hear, because then, how you have to make a decision, how do we go forward on this, which isn't always easy, but that's just a decision you have to make when in consultation with the clients on, do we leave some out and put some in, or how do we proceed? But I was at least happy to be able to see that there's at least openness to that, even though it was a little frustrating on the mathematical concepts part. Because to me, it's still just, um, the claimed operations just involve the concepts and they don't necessarily recite them. Next slide, please. So there's a couple of cases I want to talk about. Recentive versus analytics, I think, is important because just to say, you can't just say machine learning, just throw it at a high level. We're using machine learning, we're training machine learning models, and you'll be able to overcome a 101. And I think that's true. And what I've seen too, there does need to be some specificity. And so I think that's something that's important just to be able to mention and not make an easy workaround. It's not an easy workaround just to have AI in your claims. There needs to be more specificity to it than that. And we'll talk about that too a little bit more. Next slide, please. So I put 23andMe in here because in this case is really interesting. I think I was able to listen to the Federal Circuit arguments. I don't know that there's a written record of it. But there's a computer involved, but there's not a lot of details on how the computer is involved. The claim sort of has some laws of nature, some abstract ideas, and the court actually wrestled with this a little bit. Do we evaluate it under laws of nature? Do we evaluate it under abstract ideas? And they found it was more focused on laws of nature. One thing that's interesting is but there were some computational steps taking place. They just weren't super detailed, and there wasn't a lot about how it was being done. But the court held that the claims were too close to the intrinsic nature of DNA, and that there might have been an improvement in this case, which they did. They found it was an improvement in the subject matter and being able to figure out who was descended from whom. But uh, there wasn't even though it was an improvement, it still was too abstract, and so I think that's why they sort of like found against it in this case. It's very interesting to be able to sort of go through that and go through this case. Next slide, please. And then there's the Board of Trustees versus Stanford case where it talks about using a hidden Markov model to determine inheritance states, but it's more in the specification. There's not a ton in it in the claims because most of them are related to receiving and storing and providing type steps, and so there's not a lot about the computations that are taking place and how the model is being used. I think that would have been helpful. To have in the claims, and I think they could have maybe amended it to be able to be in there. And there were improvements described in the specification. So it says, you can go from 80% to 97.9%. So I think it's good that was in there, but the court said that it yields a greater number of haplotypes predictions. They said it may constitute a new or different use of a mathematical process, but we are not persuaded that the process is an improved technological process. So I think there were actually a lot of like positives within that application itself, but I think the claim scope kind of made it a little bit more challenging for this one. Next slide, please. So what are some strategies that we can use to be able to help kind of fight against some of these rejections and again, it's sort of like having a toolbox. What can we put in our toolbox to be able to help us during prosecution or litigation that can help us to be able to overcome 101 challenges? And I will say that, and sometimes and I think it's nice to have a lot of these built in because you never know what's going to work in the end. Some examiners are really focused on one thing and some examiners focus on another. But with the mental process, I think it's really helpful to describe the complexity of the inventive concepts. It's good to go through the training process and how that's being done. What does that look like? Sometimes the training process can be claimed. Sometimes it can just be helpful to be able to show that this is done, and this is a very complex algorithm. So sometimes maybe putting in the amount of data that's being processed can be helpful. And being able to include claim elements that are focused on the architectures. I feel like it's fascinating that a lot of the AlphaFold applications that I could find they were all focused on the machine learning architecture itself and not necessarily focused just on the fact that, oh, we're predicting these protein structures and their folding and that sort of thing. And so I think that if you are able to have that and you develop a new architecture and you can focus on that, I think that it will sort of steer you into I think that would steer you into the place where you would have examiners that are more used to and um, uh, dealing with AI related inventions than some 1600. One thing about TC 1600, there's a lot of it. So 1680 specifically is the one that where they have a lot of these AI and life science related applications coming in. And it used to be 1670, I think, but now it's 1680. And there's a lot of experienced examiners, but there's also a lot of new examiners. And so I think to the extent that maybe you can be in an art unit that's like 2100, that's more focused on software and used to sort of working in the AI related cases, then it can be helpful. And it's the road to patentability can be a little bit easier. So that I thought that was very interesting looking at that for the AlphaFold patent portfolio. But then they also have others that are directed to other aspects of that. But anyway, so I think that having detail on the machine learning architectures can be really helpful, and explanation as to why those so you're not having like a vanilla transformer based model, but actually why the changes were made to the model, and sometimes why the training is different. So oftentimes I found that because the data that's coming into the models is a very unique data set or needs to be a unique data set, the training and then the architecture sometimes follow from that. Not always, but sometimes, and it can be helpful to include that in there. And then I think it's helpful to include features that can only be generated by or processed by a computing device and not a human. So part of this goes back to the transformer models. You're taking the embeddings and you're processing those. And so just being able to sort of talk about a little bit about this, or sometimes a lot about this in the specification can be helpful because that's something that you can bring in during prosecution as well. Next slide, please. Next slide. Thanks. All right, great. So mathematical concepts. So I think that so example 39 again is nice because it says while some of the limitations may be based on mathematical concepts, the mathematical concepts are not recited in the claims. So it can be helpful to exclude equations from the claims, but I've seen and worked on cases where there have been equations in the claims, they've been allowed. So it's not, it's not, that you would never be able to get a patent application on a claim with an equation in it, but it does prevent an extra hurdle. And so I do think it's also helpful to avoid language that's around simple mathematical operations or mathematical operations in general. I think it's helpful to just sort of, to the extent that you can, be able to keep that out of the claims and maybe describe things in a little bit different way. Next slide, please. So it's really nice to build improvements into the specification. And one of the things that I think we're seeing in cases that's becoming clear is the claim elements really need to be tied to what the improvements are. And so I think it's helpful to be able to have that description in the specification, and then you can be able to really tie it to your invention. What I've started doing over the past few months is I put since with EnFish and so in many cases that have found that there's no abstract idea because of an improvement before at the step 2A prong 1 and the ALICE step 1. I've been putting that first. And so that's my first argument. I say, this is an inquiry that's before the additional elements inquiry. And you have to be able to, if there's an improvement, then it's non-abstract. And I actually, there was a case a few weeks ago that I argued that and the examiner agreed. And I was so happy. But I do that a lot of times and I feel like they just ignore it. And they still focus on they don't even address it sometimes in the office action. They still kind of go back to that additional elements framework. But I think that it's a nice tool to be able to have. It can be persuasive, and I think it's important to be able to put in there. And a lot, disclosure meetings, I'm always asking, how does this help? Have you done anything to help, the computer to work better? Do you make the performance better? Helping reduce resources being used, computing resources being used, and that sort of thing. So I think that can be helpful. Lots of cases will include data in the application that shows the improvements over other technologies to be able to argue that. And again, I think it's just really important to be able to connect the claim features to the improvements that are taking place. And 23andMe and Stanford are both cases where the improvements may not be enough if there's not more in there. And so I think that's where the tying in the claim elements needs to sort of really show why you have the improvements that are there. Next slide, please. And so these are all very similar, but it's a little bit more on the drafting side. One thing I did want to say is that sometimes with the processing on the mental process side of things, it can be helpful to include sometimes the speed that things are going in your example, saying, what the processors that were used, how long did it take? That can be helpful. There was a case that I worked on where uh, there's data coming off of a sequencer, and it's basically being analyzed, at the same time and the speed that the data is coming off of the sequencer. And in being able to sort of point to that and show that helps the examiners to say, oh, wow, that's um, definitely cannot be done in the human mind. And so I think that's helpful. And we did have to put a limitation in the claim about how the speed at which it was being done as it was coming off of the sequencer. But I think that helped, and that it really went to the commercial embodiment. So I think it ended up working out well. So with back to the therapeutics, I mentioned before the Vander requirements, putting that into claims can be helpful. Manufacturing context, control signals that cause equipment to operate in a particular way can be persuasive. Sometimes it can be helpful to put in the non-computational aspects. If you're synthesizing molecules, sequencing, library prep, that can be helpful. There is the divide infringement issue to be able to weigh if you put that in the claims, but I have seen that be helpful in overcoming 101 rejections. I do think it's important to put detailed examples of the architecture in there if you can, and then avoid language that characterizes aspects as being conventional or typical. And I think sometimes in the life science, there's a tendency for us to try to be able to do that because of enablement, but if we put that in, it can kind of hurt later on with 101. So I think different language is really helpful to be able to use, or not saying that it's conventional or typical at all, and just providing examples of how something can be done. I think that hurt in the Stanford case. The technical solution approach from Europe, I found can be helpful too in sort of guiding the examiners through what's going on. And then, robust specifications with lots of different strategies for overcoming 101. And then it can also help to have like certain rules. So Macro is really nice. You sort of followed a very specific rule set and rules framework. And they were able to have patent protection on that. So I try to be able to build that into, and I've actually seen that work in the case as well, a couple. So next slide. So I think we'll move on to our last topic. And then next slide for in silico data and enablement. I feel like this is fascinating. So, we have to be able to show that one skilled in the art could enable an invention. And here's the WANS factors. I thought I would just list them out for you. Some of the ones that we'll look at and talk about here are the level of ordinary skill in the art, level of predictability, and existence of working examples. So next slide, please. So, the MPEP tries to give us some flexibility. You can have working or prophetic examples, but I think, for the most part in practice, the examiners are asking for working examples. It's really hard with a prophetic example. It's not impossible, but at least it's for the most part, they're going to want a working example. The Allergan versus Sandoz case, there was a little bit of support where there was some leniency maybe in supporting enablement without a specific example, but after Amgen, it's not clear. So Allergan versus Sandoz was not like an antibody case. It was more formulation, and the formulation be claimed was outside of what some of the examples were. But the court in that case found that there was a way to be able to it was close enough for the court to find enablement because there's enough disclosure to point one skilled in the art that they could arrive at the claim formulation without undue experimentation. So I think in that case, that was what was helpful. But I think after Amgen, it's just a little bit of a different way of looking at it because that was a 2015 case, the Allergan case. Next slide, please. So Amgen 2023, they claimed an entire genus of antibodies, based on its binding. So bind to specific sequence residues on the PCSK9 and block PCSK9 from binding to these LDL receptors. There were 26 examples that were provided, and the court said that there was an enablement. It was a broad genus of claims. It would require undue experimentation, and they basically talked about how a genus is not enabled unless every species in the genus is described or it's described in sufficient structural detail. And so that was what was missing. Some quotes are, the more a party claims, the more it must enable, and that Amgen's offers persons skilled in the art. In the case, in the specification, Amgen offers persons skilled in the art little more than advice to engage in trial and error. Wow, I think that's harsh, but that's sort of where we're operating now and trying to be able to evaluate, when we're doing functional claiming for these sorts of things, how are we going to use that? Are we going to use it at all? So I think it's just caused changes in this. Next slide, please. So in response to this, since Amgen didn't really explicitly talk about the WANS factors, I think the USPTO felt like, we have to do something. We have to make sure that, everyone's, still thinking about WANS. So they had guidance in 2024 that said, we'll continue to use the WANS factors. We want USPTO personnel and the public to know that we're going to be, implementing the Amgen case. We're not making any major changes and we still want to be able to use the WANS factors. And so, in Amgen, they, like I said, they didn't specifically mention it, but they did mention the factors in there about unreasonable, undue experimentation and those sorts of things. But they didn't explicitly mention the WANS case. Next slide, please. So I started seeing more about, can AI help alleviate the undue experimentation burden? So can AI help to predict compounds within a claimed genus? So can you expand your genus based on what AI tells you predicts could also be other molecules that are within that genus? And especially if you're able to take one that the AI generated that says in the genus, and then you actually do experiments and show, oh, yes, this works. Could that be something that helps you to be able to expand the size of your genus? And so the tools are getting really good at this sort of thing, but I think that there's just a lot of hesitation to do this, and I wouldn't necessarily recommend. So I think that it's one of those things where if you have nothing else, if you want to be able to try and expand it, it's might be helpful to try and see how it goes. It might not go very well, but it might be helpful to try and use it, and maybe the law will change going forward. But I think it's just sort of with eyes wide open that Amgen had, they said that they had 26 examples, and that's what the court seemed to be wanting to give them. That you just have to be able to make sure that you have sufficient experimental data and provide a roadmap to anyone skilled in the art and how to be able to get to the claimed genus if you're going beyond your compound. So I think that's just something important to know. But I'm seeing articles where some people are saying the predictive level is so high that you can use this really well. And courts should be more open to this, and the USPTO should be more open to this, but some are not. So it's just one of those things. So next slide, we'll kind of go through this a bit quickly. I don't have very much more. So EPO appears to have some openness, at least they're talking about it. So they have a sufficiency standard rather than an enablement standard, but one of the cases talked about a claimed therapeutic effect may be proven by any kind of data, as long as they clearly and unambiguously reflect the therapeutic effect. And then next slide, please. So then there's a couple of cases that weren't related to sufficiency, but like industrial applicability and inventive step, where they specifically mentioned the in silico studies. And I thought this was it sounds very, very, British to not sort of like throw it in the bin approach. So if you have an in silico examples, don't just throw it in the bin. There might be some usefulness to it. And so in this one case, it helped to show industrial applicability. And then in the other case, being able to show inventive step based on an in silico study seemed to be able to be working for them. So I thought that was interesting. So Europe is at least talking about this, and there's some decisions I could find. Haven't been able to find anything in the US yet. So next slide. This one and one more. So relying only on in silico data for enablement or sufficiency purposes would be risky. I feel like that's true. I think it would be hard. I would really caution it, but maybe you can, and that support for claims needs to come from a working example, but the potential exists maybe to be able to try to expand the claim scope in some situations based on in silico data. I feel like it's an unresolved issue, and I think it might take time. And perhaps as the technology advances, we'll be able to, and predicting events that are otherwise unpredictable, maybe patent offices will be more open to this sort of thing. And then my last slide is just, interestingly, the FDA appears to just say, this is great. We're going to phase out animal testing and we're going to focus on AI-based computational models. So two regulatory agencies, different regimes, different ways, different laws, different everything, but they really seem to be focused on trying to be able to use AI-based computational modeling. And for me, the interesting part of this is, um, will this affect at all the discovery process and how much because the on the FDA side, because you might not need to be able to have animal experiments if you do things using AI models, um, is that going to affect the R&D process? And then therefore, does it affect the kind of data that's being used? And then therefore, will that somehow affect the patent process? So I think that's just something to kind of be aware of and know is out there. So I think this is a really interesting topic. It's not super practical right now. Maybe it will be. Folks are talking about it, and I guess we'll just kind of see how the law develops. So thanks a lot, everyone, for staying. Um, I don't know, Nicholas, if there's any questions. We don't really have time. Sorry. If you have questions, please feel free to email me or give me a call. I'm happy to talk about these things more. And I just really appreciate you taking the time to be able to listen today. Hope some of the information was
Well,
helpful.
well, thank you very much, Trevor. That was an excellent presentation. You got through a lot of material there. I do have a couple questions, most of them regarding the AI and inventorship. So here's the first one.
Mhm.
It appears that there could be disputes on inventorship when inventors of AI tools that are used in identifying leading compound or therapeutic proteins claim inventorship for such compounds and proteins. So this is the inventors of the tools for
Mhm.
finding these compounds or proteins claiming inventorship. Are you aware of such disputes, and what do you think about their outcomes?
That's a great question. And I am not aware of those disputes, but one thing that with inventorship that might be helpful on the compounds because the AI, that's really interesting. So I have heard of situations where like there's licensing, there can be a licensing back and forth on that, where you have a company who's generating the molecules and then they provide them to another company, and then they're sort of using them. So then they use that as a potential target. Um, One thing that's interesting on the output of the AIs and sort of showing the molecules is that um, oftentimes, not always, but I think it probably almost every case, but there might be cases where this doesn't happen. But generally, you have to be able to sort of take that molecule, and then there's a lot more to it. You might have to make changes to the molecule for solubility reasons, or there might be other things that end up needing to change just outside of the molecule itself once it's generated. So I think that sort of more reduction to practice, and there could be some conception in there too. And there's actually a webinar I did last year that talks a little bit more about this. Um, but there could be some you could avoid sort of AI issues in that situation if you've sort of taken a molecule and you've had to do some inventing in order to be able to get it to the point to where it actually can be used within a subject, within a human or another subject. So I hope that answers the question. But I think that I haven't seen any disputes like that yet. I've seen licensing back and forth in agreements, sort of trying to iron some of those issues out. And then I do think that if you're sort of taking the molecules that are coming out of the AI and you're needing to do things to them or the formulations that they are within before they can be administered, um, there's different inventing around that. Then that's like another way of securing inventorship for those types of molecules in those situations.
I think that's a good answer. It's certainly an emerging area, and I expect to see cases toward that topic
Mhm.
sometime in the future. Here's a related question. How do you handle novel compound libraries generated using AI in the drug discovery process? Who is the inventor?
Right. And so I think that kind of goes back to what I was saying before, where you sort of have to be careful. So if you have a sequence that comes out and you take that sequence, you're not making any modifications to it, and you're sort of able to maybe figure out an environment that it can be administered in um, using only AI, then I think that can be really challenging. And so I think it's trying to be able to identify when you have the AI is generating all these compounds, even if it's novel, what does it take to be able to be able to make sure that that compound has some efficacy. And if there's likely going to be human intervention within that process. And so in that way, you can be able to show that there is so there's a human inventor. But and then if you're doing just if you're doing the model, then there could be, inventorship, human inventorship on the development of the model. But then if you're just taking the sheer raw output from a model that's already been developed and trying to be able to claim that, I think that's going to be harder. And so I think that it's being able to try and see how that output is narrowed down in order to be able to find a target that actually works. Because there's a lot of work that has to be done. Once you have the target, there's a lot of work that has to be done before it can actually go into a human and then actually work for its intended purpose within a human. And so that's where sometimes the human inventorship can come in as well. But I think, yeah, that's really hard. And it's something to be able to just be mindful of if you're trying to be able to just sort of like just trying to patent just a sheer sequence without anything else that's come strictly from AI only.
I agree, and I think that answer really underscores the importance of keeping careful records of the interaction between the human beings and the AI, because
Mhm.
there's almost certainly some sort of inventive activity occurring as the prompt drafter drafts their prompt that caused the AI to find those novel compound libraries. Um,
Mm.
so so here's another question that came in from during the subject matter eligibility portion of your presentation. And the question is this: in an infringement scenario, how discoverable is the use of acclaimed machine language architecture?
So that's a great question. And sometimes it's hard. It's not always easy to be able to the discoverability in lots of AI isn't always easy to be able to say, well, how do I show that somebody is actually using my architecture? The one thing I have seen that helps with this in the life sciences space is that folks publish and present a lot. And because of this, there's more information out there as to who is doing what, and if there might be hints that somebody is using a similar model to what you've developed. Sometimes that you can see that in presentations and in papers. So it's just being aware that that's out there, but the discoverability is harder. And so there's a lot of talk about trade secrets and do you want to be able to keep something? And that's another discussion for another day of, should that be considered to be trade secret? And I think that that's always something to be able to sort of talk about with companies is do you want to keep this trade secret? Do you want to patent it? And all of the considerations that go into that because the discoverability is not always easy. But I think in the life sciences, it's easier than in some of the other cases where you have people that are doing lots of publications on this sort of thing.
It's a complex issue, might deserve its own presentation.
Yeah.
One last question. I think this is an easy kind of an open-ended question about how you feel about things. So the question is, what issue connected to AI and the life sciences do you personally find the most interesting to follow?
For me, I feel like the last one we talked about, the in silico data, that's one captured my attention years ago, and I just thought, oh, that's to me, it's so fascinating that that it's getting to the point to where you can, be the predictions made by the machine learning or can be better than animal models, and why would we rely on those or even data that comes from those to be able to show enablement? And I think the FDA has recognized that and said, wow, yeah, if you can show that this model is actually better than other types of models, then we'll be okay with you using that, at least in some cases. And I hope maybe that the patent laws will sort of move towards that a little bit more. But to me, that one's just really fascinating. I think the technology has come so far and that it could you really help and make a lot of changes. Hopefully, it can help folks with Amgen at some point. I don't know that it can now, but maybe down the road. And so, to me, that's just fascinating that we've come to that point where you can do that, and why patent offices aren't more open to it. I can understand why, but I think that at least important to be able to have a discussion around. If you can actually show that your model has these really good results and maybe even better than other experiments, I think it should, it should at least be considered. So that's an issue that I think is really interesting.
That certainly is fascinating. I mean, the cost savings of being able to
Yeah.
do these experiments in a computer instead of in a lab, just on its own. The fact that we're able to actually accomplish that in certain areas is in biology or chemistry is pretty amazing. It's definitely the future, and I expect to see a lot more development of cases in that area. Well, that's all the questions for today, Trevor. Again, I thought you did a fantastic job. You got through an enormous amount of material and you picked up on a lot of nuances in those three areas that I haven't ever heard anybody talk or write about before. So fantastic job. Thank you, kind audience, for staying logged in until now and for attending the presentation. If you do have any additional questions, please feel free to email me or Trevor. And again, a link to the slides for today's presentation will be emailed to you. I hope you will tune in to additional episodes of the SLW Chemistry and Biology Seminar Series. Thanks so much for your attention. Have a great day.